Sorry for the delay. We are just having some technical issues, but we will go ahead and get started here momentarily. If I could ask you all before we get started, for those of you who don't know me, first of all, I'll make a quick introduction. I am Hannah Shea with World Law Group, and I work with our practice and industry groups. Our technology is hosting today's meeting, which is an EU Artificial Intelligence Act update. If you'll recall, we did one last June. Some things have obviously taken place since last June. It's been almost a year. And so Johannes will be giving us an update on that today. Before we kick off, if you wouldn't mind renaming yourselves, and you can also send me a chat if you need help renaming, but you hover over your own video and click on the 3 dots in the upper right corner. Select
Got it.
to include your firm name. And if you haven't already, I am trying to mute everyone, but if you haven't already muted yourself, please go ahead and do so. This meeting is being recorded, just so that you know. You'll see the little sort of live stream at the top. That means it's being recorded. And we have our artificial intelligence note-taking service with us today, so that we can provide you some takeaways along with the recording. With that, I'm going to go ahead and hand it over to Johannes so that we can get started. If you do have questions, feel free to use the raise hand feature at the end or drop them in the chat. Johannes.
Yes, hello. Thank you very much, Hannah. I'm Johannes Johanek of CMS in Vienna, Austria. I'm the managing partner of this firm and also heading the TMC department. And apparently I'm the one who speaks about artificial intelligence without being able to share my screen. So I had to ask Hannah for her help, and please excuse me that I will have to tell her to move the screen whenever I come to changing it, because, as I said, I'm unable to do it. I'm talking today about the general purpose AI. That's a topic which has been introduced into the AI Act, which was adopted by the European Council this February and approved by the European Parliament in March. The formal adoption is expected to take place in summer 2024. What are the objectives of the AI Act? The new European legal framework for trustworthy AI aims to establish harmonized rules in the European Union for the development, for the placing on the market, and the use of products and services in which AI technologies are embedded or of a standalone AI application. The aim is to ensure a level playing field and protect all European citizens while strengthening Europe's competitiveness and industrial base in the field of AI. Whether the European Union has achieved this goal can be discussed. At the heart of the regulation are harmonized rules for the development and use of so-called high-risk AI systems. In order to be authorized in the European Union, several requirements must be met. These include, for example, the creation of a risk management system, compliance with data protection laws, and technical documentations. The legal framework applies to both public and private actors inside and outside the European Union, provided that the AI system is placed on the market in the European Union or people in the European Union are affected by its use. The creation of a Europe-wide legal framework for artificial intelligence applications also means that national isolated solutions are avoided and Europe's industrial and technical performance is promoted with a common solution for the AI regulation. The European Union is of the opinion that artificial intelligence will define the world in which we live in the future. To help building a resilient Europe for the digital decade, people and businesses should be able to enjoy the benefits of artificial intelligence while feeling safe and protected at the same time. The AI Act responds directly to citizens' proposals from the Conference on the Future of Europe, most concretely to Proposal 1210 on enhancing European EU's competitiveness in strategic sectors, including countering disinformation and ensuring humans are ultimately in control of the artificial intelligence, and on promoting digital innovations, while at the same time ensuring human oversight. The European Artificial Intelligence Strategy aims at making the European Union a world-class hub for artificial intelligence and ensuring that artificial intelligence is human-centric and trustworthy. Such an objective translates into the European approach to excellence and trust through concrete rules and actions. The AI regulation was also developed as part of this European strategy, a set of rules that is based on a risk-based approach and aims to put the individual at the center of the regulation. So, what are the key proposals or the key provisions that can be identified from the AI Act? Article 5 lists banned applications which are prohibited at all, such as emotion recognition and workplaces or schools, social scoring, predictive policing, or in general, the manipulation of human behavior through artificial intelligence. As exceptions, Article 5 provides that law enforcement authorities may use real-time remote biometric identification systems in publicly accessible spaces in the case of abduction, trafficking in human beings, sexual exploitation of human beings, as well as the searching for missing persons. In the following articles, clear obligations are stipulated regarding high-risk artificial intelligence systems due to their potential to cause significant harm to health, safety, fundamental rights, the environment, democracy, and the rule of law as such. Examples include artificial in critical infrastructure, education, employment, essential services like healthcare and banking, law enforcement, migration, border management, justice, and democratic processes such as elections. These systems must assess and mitigate risks, maintain usage logs, ensure transparency and accuracy, and incorporate human oversight. Persons retain the right to lodge complaints regarding AI systems and receive explanations for decisions influenced by high-risk artificial intelligence that impact their rights. Further transparency requirements are stipulated with respect to general-purpose AI systems, which is the topic of today's presentation. In this sense, these AI models need to comply with European copyright law, for example. Furthermore, AI-generated or manipulated images, audio, or video content need to be clearly labeled to be recognizable as such. Further articles concern measures to support innovation, governance on a national level, and in this sense, member states are obliged to establish a national authority that is designed to oversee the artificial intelligence. I would like to give you also a brief definition of what the AI Act understands as artificial intelligence. These are machine-based systems designed to operate with varying levels of autonomy that may exhibit adaptiveness after deployment. For explicit or implicit objectives, infers from the input it receives how to generate outputs such as predictions, content, recommendations, or decisions that can influence physical or virtual environments. I would like you to change to the second page, please. The Artificial Intelligence Act provides certain safeguards on general purpose AI. What is a general purpose AI? According to Article 3 of the Artificial Intelligence Act, general purpose AI is an AI model, including where such an AI model is trained with a large amount of data using self-supervision at scale that displays significant generality and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market, and that can be integrated into a variety of downstream systems or applications, except AI models that are used for research development or prototyping activities before they are released on the market. The AI Act stipulates certain transparency requirements regarding GPAI, which is the short form for general purpose AI. Further, the Act acknowledges that providers of general purpose AI models have a particular role and responsibility along the AI value chain. These models serve as the foundation for downstream systems, often utilized by downstream providers and necessitating a comprehensive understanding of the models and their capabilities. As such, proportionate transparency measures, including the preparation and maintenance of documentations, are essential. This documentation should encompass technical details and be readily available to downstream providers. AI offices and national competent authorities, upon request, must also be presented with these documents. The regulation empowers the Commission to adjust the annexes, outlining the minimal set of elements in the documentation to adapt to technological advancements through delegated acts. In Article 51, certain thresholds are stimulated if a general purpose AI is classified with a systematic risk. The risk-based approach of the Artificial Intelligence Act is also clearly evident in its classification. If this is the case, the provider of this system shall notify the Commission and the respective procedure takes place. So can you go to the next page, please? Providers must notify the Commission promptly if their general purpose AI model meets the specified requirement, providing necessary information to demonstrate compliance with the AI Act. Providers may present substantiated arguments along with their notification to demonstrate that the AI model does not pose a systematic risk to specific characteristics. If the Commission finds the argument insufficient and the model still poses a systematic risk, it rejects the arguments, classifying the AI model accordingly. The Commission can designate AI models as presenting systematic risks on criteria outlined in an annex to the AI Act or upon a qualified alert from a scientific panel. Providers can request a reassessment of the designation, providing new reasons at least 6 months after the initial decision. The Commission may consider the request and may reassess the AI periodically. The Commission also publishes and maintains a list of general-purpose AI models with systematic risks while ensuring protection of intellectual property and confidential information according to the relevant laws. In case the general-purpose AI is considered a systematic risk model, additional obligations apply to the general transparency obligations. Can you please model to the next page 4, please? Model evaluations in accordance with standardized protocols and tools reflecting the state of the art. Assignment of mitigation and possible systematic risk. Keeping track of the documentation. Ensure an adequate level of cybersecurity and the reliance on codes. Practicing and demonstrating compliance with the obligations as out under this provision. For all GPAIs that do not fulfill the requirements of Article 51, certain transparency provisions apply. Providers must document the training of the AI systems and must also ensure that copyrights are protected as well as confidential information and business secrets. Providers shall comply with the obligations under the regulation even if the GPAI was trained in another jurisdiction. GPI providers cannot cheat, and there are no exceptions to these documentation requirements insofar as the open AI and all information is publicly accessible. Okay. There are risks associated with biometric identification systems, which are highlighted in the recitals in number 32, where the usage of biometric identification where the use of biometric identification can lead to biased results and entail discriminatory effects. Such effects are particularly relevant with regard to age, ethnicity, race, sex, or disabilities, and thus are mostly prohibited. Can you move the page, please? The use of biometric AI systems for law enforcement purposes should be restricted to specific situations where it is strictly necessary to achieve a substantial public interests, and these interests must outweigh the associated risks. These situations include the search for missing persons, addressing threats to life or physical safety, identifying perpetrators and suspects of serial criminal offenses. These thresholds ensures that the offenses are sufficiently serious to potentially justify the use of remote biometric identification systems. These criminal offenses are based on a list as outlined in a so-called Council framework decision, considering the degrees of necessity and proportionality. An imminent threat to life or physical safety can arise from serious disruptions of critical infrastructure, which could lead to severe harm or negative consequences for the population and the functioning of the state. Furthermore, the regulation allows law enforcement, border control, immigration or asylum authorities to conduct identity checks in the presence of individuals concerned. This preserves the ability to identify individuals who refuse to disclose their identity or are unable to do so due to accidents or medical conditions without requiring prior authorization. Can you please move to page 6? In the most recent and finally adapted version of the AI Act, social scoring is no longer restricted to public authorities, but the use of AI for social scoring purposes is generally prohibited. Both private and public authorities and companies are therefore not permitted to use artificial intelligence for social scoring. According to the Act, social scoring exists if four conditions are cumulatively met. The AI systems are used to evaluate or classify natural persons on the basis of their social behavior. The evaluation or classification occurs over a certain period of time. And the social scoring finally leads to detrimental or unfavorable treatment of certain natural persons or groups of persons that is unjust, justified, or disproportionate. And the application is constitutes a detrimental treatment which is applied unjustly or disproportionately based on the social scoring generated by AI systems. The reasons for the banning of social scoring or seeing it as prohibited is that according to the recitals of the AI Act, such systems may lead to discriminatory outcomes and the exclusion of certain groups. Also, certain NGOs have warned that the use of such AI systems in connection with social scoring. For example, Human Rights Watch writes that these systems are already operational in certain countries, where, for example, in France, La Quadrature du Net has repeatedly denounced and documented a social scoring algorithm used by France's family benefit funds known as the CAF. Furthermore, the AI application is prohibited to use and manipulate and exploit user vulnerabilities. Can you please move to page 7? In the latest version of the AI Act, the Council extended the scope of the prohibitions on manipulation and exploitation to AI systems so that they do not intend to manipulate or exploit, but which have such an effect. AI systems manipulating people must not be placed on the market if four cumulative conditions are met. The manipulation through deploying subliminal techniques beyond a person's consciousness, or purposefully using manipulative or deceptive techniques, objective or effect of materially distorting the behavior of a person or a group, and causing the person to take a decision they would not have taken otherwise, in a manner that causes or is likely to cause that the person or another person infringes significant harm. Can you please move the page? The AI Act also provides for certain legal remedies and the right of consumers to launch complaints and receive meaningful explanations. Any natural or legal person having grounds to consider that an infringement of the Artificial Intelligence Act provision has occurred may submit reasoned complaints to the relevant market authorities, which is comparable to the GDPR, where data subjects may only submit complaint if the process of personal data relates directly to him or to her. This is also the case in the AI Act. The right to explanation of individual decision-making means that any affected person has the right to a meaningful explanation on the role of the AI system in a decision-making process and the main elements how the decision is made. Only to the extent that an explanation right is not otherwise provided under union law, the conflict of interest between person requesting explanations and providers who block or restrict such requests on the grounds of know-how protection. So this was a quick overview on the provisions of the AI Act on general purpose AI. I believe most of you will have read this piece of law. It's an incredible voluminous piece of law, probably the most voluminous in the field of digital regulations, more than 400 pages. And general purpose AI is only one topic of them. And I would like to open the round for any questions or discussions now, and would like to open the floor.
If anyone has any questions, feel free to use the raise hand feature, or you can drop into the chat if you have a question as well. So Johannes, is this this is in full effect, or is there a period of time at which companies need to come into compliance with this?
Yes, so we assume that this whole piece of law will be effective this summer, 24. But there are various chapters in this regulation which will become effective within the next year and the year after. So it's not everything at once. But basically, we are getting requests concerning the AI directive already, because what it means for the clients is that they need to face a very thorough compliance scheme, transparency scheme, reporting scheme, and also if they run a high risk applications, that they need to prepare the notification to the relevant authorities to get clearance on their systems, because for a so-called high-risk applications, a formal registration with the authorities or with the relevant bodies is required.
And what are considered the high risk applications?
High risk applications, there is a definition in the Act itself. Basically, these are applications which, due to their vast application, due to their big amount of data they are creating, they are supposed to have a large influence on people using this AI, and pose a risk that people are influenced by the outcome of such a AI application.
Okay. And Johannes, do you think that there will be any industries in particular that will be really mostly impacted or more heavily impacted than others?
Yeah, I mean, everything that can be considered a high-risk application. I have requests from the health sector, for example, computer systems, AI applications running medical devices, computer tomographs are affected. Also profiling applications. For example, I'm considering banks, I'm considering insurances, I'm considering many companies of public interest. So this is not restricted to a certain industries, but these large-scale industries running these high-risk applications, of course, will be mainly affected. I mean, I can say everything that can create a real danger or threat will definitely be affected by this. Our clients, I mean, according to my experience, banks, insurance companies, and in particular healthcare companies.
Okay, excellent. Any other questions? Those were the only ones I saw in the chat to me. Is any before we close out, I know this was supposed to be 30 minutes and the second 30 minutes for Q&A. Is anyone else in their jurisdiction, and I know we talked about this earlier in the year, but we have some different jurisdictions here today that are working on models, you know, any regulatory models in their own jurisdictions, sort of echoing this, or go ahead, Ben.
Okay. Hi, Ray. Yeah, I mean, it's the same jurisdiction in the end as Johannes because I'm working in Munich, so it's Europe, as many of us here. But I'm just taking care of product liability, product safety issues, and I'm not so much an IT lawyer, but I'm coming from that end, so from the product safety side. And I see that this is, well, it's the whole model, like the law is forged, it's a product safety law. So I was looking forward to hearing Johannes' discussion presentation here today because I was writing a letter and an essay about it from the German perspective. I mean, it's a European perspective on this one, and I see it as well that it's quite a long piece of legislation, as Johannes just said. It's not the easiest thing to read, and I pity a bit those. Well, all of us somehow we have to work for it. It's a more pitying the clients because for us it's good. I mean, it's lots of work, but it's not the best piece of legislation I would have seen. I don't know, Johannes, what you think of the quality of the legislation itself. I think it's not perfectly well drafted, maybe due to the fact that it's going on and forth also in the parliament, back to the parliament again.
So thank you for this question. I mentioned it briefly at the beginning, but as a matter of fact, this is for me an example of bad legislation with a good intent, basically. But in fact, you get 200 pages of introduction of programmatic text, as a matter of fact, and then you get a lot of provisions with tons of undefined legal expressions. I think it's very problematic to use expressions like should apply adequate means, should apply proportionate means. This is actually a program for a disaster because the authorities will pick this up. And since the punishment for violations of these regulations are quite high, they will delightfully apply penalties as they do according to the GDPR. And also in the GDPR, we have sometimes the problem that that provisions are not clearly defined. But compared to the AI Act, the GDPR is a masterpiece, I think. And it will lead to a lot of uncertainty. And this uncertainty will not motivate the industry to develop and apply and deploy artificial intelligence products here in Europe. It's a piece of law which is basically well meant because I agree that we must have regulation because the topic is too hot and too dangerous to leave it completely unregulated. But the question is whether this immense piece of law is the right way to approach. Now, do I have suggestions for a better law? Me personally, I don't. I'm also not involved in the lawmaking, in the creation of this act. But I think it follows a pattern which is recognizable in the past years, which means that Europe is becoming less competitive if you compare it with the United States, if you compare it with Asia. So that's the political announcement, which I gladly give because it's my opinion. I understand and I acknowledge that there will be people who have different opinions. But also to get back to the first part of your questions, which relate to the relation of the AI to other acts of law. The AI Act of Law does something many digital acts do. They say this act leaves the other acts on digital digital matters unaffected. Which means it stands next to the product safety rules. It stands next to the product liability regulations and laws, and directive and laws. So these are acts of law which will have to be applied in addition, and which can create more headache to our clients. And it is also clear that since AI applications can work and will work with personal data, that there will be a clear relation and dependency on the GDPR, and a violation of the AI Act at the same time may be a violation of other acts, in particular the GDPR as well, which can lead to horrific penalties.
So Johannes, oh, go ahead, Sabrina.
How are you? Very interesting. Thank you very much. I have a question. It was mentioned that the new regulation imposes legally binding rules requiring to tech companies to notify people when they are interacting with a chatbot or biometric categorization or emotion recognition systems. And it also requires that to label the deep fakes or the deep fakes generated content. Is that enforceable right now? Because it looks like from here, from South America, we interact with artificial intelligence and everything, and it just looks like it's a commitment that the companies have regarding these very important issues. And I wanted to know, when will this be enforceable, or if this is enforceable right now, because it is not clear to me, that part.
Right now, this day, it's not. It's becoming, there are few formal steps to be taken. But as regards the interaction, what I did not do today, I did it last time when I gave a presentation on the AI Act when it was still a draft. I think it was 2 years ago. We have a risk-based approach, and there are prohibited applications where you don't have to react, or where you don't have to interact with an authority because you must not do it. And then you have high-risk applications where you have to register your AI applications. Then you have the low-risk applications where you do not have to do that. And then you have the general purpose AI. So, and the general purpose AI can also technically be a high-risk application, or it can be a low-risk application. But in fact, they will pose what the AI Act define as a systemic risk. And the systemic risk is defined in the AI Act itself. And therefore, the Act prescribes certain obligations the deployer of such a system needs to obey, which is a model evaluation, an assessment and mitigation of possible risks, keeping track and documenting and reporting, and ensure adequate level of cybersecurity protection. And there's also the possibility that you may rely on certain codes of practice if they are predefined applications, but they do not exist yet. They need to be worked out. But a lot of this must be proven by application after the summer of 24.
Zhang, I see you've got your hand up.
Well, I think Dimitri's put his hand up before me, though. Dimitris, would you like to go first?
Fine, whatever. Yes, thank you. Very pleased being with you today. I would like, if I'm allowed, to make 2 points. The one relates to the previous discussion, and to note that there is already underway the AI Civil Liability Directive, the proposed AI Civil Liability Directive, which is worked out together with the revised Product Liability Directive. It relates to previous discussions. So it appears that indeed we will have similar and parallel legislative pieces within the EU covering the same topic overall. The AI Civil Liability Directive will deal with the non-contractual liability. I'm afraid this is unavoidable since the law follows life. And since we are moving towards, we are already within the digitalized era and life, such regulation appears unavoidable. Of course, I agree that it may raise concerns to clients and to us, trying to accommodate client needs. This is my first point. And my second one is that I would like to connect AI with the collective redress. Perhaps all of you know about RAD, the Representative Actions Directive, already in force since last June. RAD is an example of an horizontal legislation of collective redress. You may recall that the discussion started many years ago. Initially, the thought was to legislate collective redress regarding competition, competition law issues, and it ended up to an horizontal legislation of collective redress, very significant movement. Now, I don't know if already or the AI Act will be added to the annex of the RAD. Direct annex is all legislative pieces which may use as legal basis for a collective redress. So another, therefore, important issue for clients and for us, for review and evaluation, will be collective actions, injunctive or for redress regarding AI issues, AI breaches. These were my 2 points, and thank you very much for your discussion.
Yeah, I think, apart from the collective redress, where, I have to say for my country, Austria, the respective directive has not been transposed into national law, so we don't have it yet. We're still fighting about it in Austria. Maybe other countries have the same problem, but basically, I think if you violate a rule of law, according to the civil law system, you have a reason to file action for damage compensation if you can prove that you're damaged. This is the case under GDPR. GDPR explicitly mentions this. This will be the case under AI Act. And the legal remedies that are described in the AI Act they are geared to the person affected as such. So this means I need to be personally affected or incur a damage in order to be able to file action or to lodge a complaint to the competent authority. There is no collective redress provision in the AI Act as such, but it is very, I mean, it would be a good example of collective redress, because I can imagine that if something happens with an AI application and AI applications create a damage because they have a malfunction, or maybe they exceed their purpose, then it will most probably be more than one person affected by this failure. It will be a group. So probably this group can be defined clearly and would be eligible for a collective redress procedure. But not in Austria for the time being, because we haven't done our homework and we have not established a collective redress law according to the directive yet. I cannot give you the answer for the other states in Europe.
Okay, I can tell you that most of the 26 member states have already implemented RAD. Some other states of the parliaments and so on. I mean, I believe that in Austria, it is unavoidable that at the end will be implemented as well.
I think we will be punished. We will be punished for running late.
Okay.
Arata, it's to you. I see that you have your hand raised.
Oh, yes, thank you. My question is, does the law, can you hear me?
We can, yes.
Yeah. Does the law provide clear standard for documentation requirement, or what's manipulative and what's not clear enough for the businesses to understand what's the boundary and how to comply?
The answer is a clear yes. It requires that. And it is required for general purpose AI, as it is for any other artificial intelligence system, but in particular on the general purpose AI, and also in the high risk applications, because there you need the documentation to notify and register the system with the competent authorities. So
what I wanted, I'm sorry. What I wanted to ask is, when you say there's a documentation requirements that has to be followed by provider of general purpose AI, what kind of documentation is required? What has to be described there? What's the I think you mentioned some minimum requirement, and I was wondering how clear that minimum requirement is for companies to understand to implement by themselves.
Well, I mean, what the Act says is that you need model evaluations in accordance with standardized protocols and tools reflecting the state-of-the-art assessment and mitigation of systemic risks and so forth. I'm not, because I can only read them again, which I think is not the purpose. But I believe that this will go very deeply, and that these documentations and evaluations need to be comprehensive and give the authority the overview that is necessary to have an in-depth understanding of what is going on and the logic that is behind it. So this is not what I have read about it, because I haven't done it. It's premature. It's coming into force now. So nobody has asked me to assist in assisting in model evaluations and mitigation assessments from a legal point of view. But what is clear from also relying on the principles of the GDPR, that you have to go very deep and to explain and evaluate the risks comparable to a risk evaluation you do with a privacy impact assessment, just a lot deeper, because it's a lot more complicated.
I see. Do you know whether the regulator will going to provide some kind of guidance or guidelines detailed enough for the business to understand what, you know, what how the law will be enforced, or it is not so clear or expected at this time?
Yeah, I mean, the general, I mean, the AI Act contains provisions of that kind, saying that the competent authorities shall provide guidelines, shall recommend. So this is clearly written in the AI Act. But my experience, coming mostly from the GDPR, is that the authorities make it very easy for themselves, because when you ask for the guidelines, you get answer like the lawyers must evaluate that. We are not here to give legal counseling, so we only give counseling and recommendations on a general level. But the general level is never case related enough to be helpful.
Certainly. Yes. Then I think that's very interesting that because in Japan, although we don't have laws like AI Act in EU, but the government actually published pretty detailed guidelines for the business to, you know, mitigate the concerns that expressed in the EU AI Act, like starting from the very principles about the risks in AI. So the approach is different, but I think that the attitude of the regulators are also different, and you know, it's very interesting attitude of the EU regulators, that although they have the law, but they don't really guide the businesses how to implement. It's the opposite here. So
this is what I initially said. It's full of undefined legal expressions, which makes the whole thing a little bit dangerous, because it's very easy to write, you have to apply adequate measures without saying what adequate is.
Yes, exactly.
Is that the authorities will decide it, and the courts will decide it finally, which is all good and fine, unless you are the first client who is caught by the authority and drawn into proceedings, because you will be the guinea pig. And it would be a lot better to have these kinds of guidelines. But for example, in Austria, the broadcasting authority, the authority competent for broadcasting and telecommunication matters, has been nominated as the competent authority. They've never done with such a thing before. And the reason why they've given it to this authority, according to my impression, is because apparently there are personal resources, or they have time, or I don't know. The question is, why the telecom regulator? This is not conclusive to me. And if you if you go on the website of the telecom regulator, they say that they are competent for that. But if you click on the link, you get this site is under construction. And I wonder how long it will be under construction.
Mm.
And that shows to me that at least the Austrian regulator does not have any guidelines or any usable documents where you can actually which you can use for counseling a client. What we do is we read what we can find in the literature. We can read what is written in the law and in the recitals of the law. I mean, if you read the recitals, then you get quite some information what the purpose of the law is. But it's a 250-page exercise, if not more.
I see.
So it's not going to be easy, and I think this is going to create a lot of questions. And this is the reason why I said some time before that I believe that this piece of law is not helpful for Europe to stay or be competitive. And the purpose, which is so nicely formulated, that the European Union aims to create a legal environment to be the go-to place, the go-to jurisdiction for the development of artificial intelligence, has not been achieved by this, I guess. I still believe that the US and probably also Asian countries will have a better environment for developing solutions, AI solutions. And you can see this effect also in other laws of the European Union, like the Data Act, for example.
I'm conscious of time. We're about 5 minutes past the hour, but I do want to thank you. You know, I don't know whether to say this is an exciting time for lawyers in your space or a challenging time or a bit of both. You know, it seems that this very lengthy EU AI Act has left us with a lot of questions that are open to interpretation, or a lot of regulations that are open to interpretation. So definitely keeping you guys very busy. But I want to thank you, Johannes. This definitely won't be the last conversation we have surrounding EU AI regulation or AI regulation in general throughout the globe. But I want to thank everyone for joining us today. And until next time, if anyone is attending the iTech Law Conference this spring, please let me know. Send me an email. We'll try to get folks together who are attending that for lunch or coffee or at least some individual one-on-one meetings.